in a room where truth faces power. Every word can change a life. A judge stands firm, a defendant holds his fate. No mercy. No delay. Only justice, raw and unfiltered. This is where silence breaks, and destiny is decided.
5-14106F8. Appearances from counsel.
Nick Carnes on behalf of the people.
Thank you. Mr. Shook is here in person, and joining me via Zoom today is another attorney apparently standing in or works with Ms. Satawa. Ma'am, your name?
Lynn Getz on behalf of Mr. Shook.
Thank you. All right, Ms. Getz, I know yesterday the council were asking for a stipulation to adjourn. I want you to let Ms. Castle or Ms. Satawa know. Part of the reason was there was no explanation as to why people weren't available on the stipulation. So I didn't know if they were just taking the day off, if they were going to a spa. I now understand they probably were at CDAM conference. So that's why I did that. There was no justification. So I wasn't trying to be rude for some reason. But also I know that this case here is set for a final pre-trial conference. And that means it's one of the cases set for trial in a couple of weeks. I think that date was November 18th, 25th. I don't know why I said 18th. 18th must be over in Lake City. All right, so I don't want to lose that potential trial date either. So do we have a resolution in this case today, Ms. Getz, or do you need to speak with Mr. Shook, or what do you know?
Your Honor, I did speak with Ms. Kessels, who spoke with Mr. Shook, and at this time, I do not believe that there is a resolution in the case. Mr. Shook expressed to Ms. Kessels that, in fact, he was desirous of going to trial on this matter. There is a conflict in our office with the 25th date, however. We have previously scheduled trials on that same date. Was wondering if there was any way to move it just even to December 2nd.
Okay. The answer to your question I'm going to give to you in just a moment. Mr. Shook, I have this conversation with everyone on final pretrial conference days, which are always Friday mornings. And it's not designed at all to encourage any kind of pretrial agreement. I don't know anything about you, and I don't know anything about the case other than what I see on a one-page felony information. I don't know what the evidence is. I don't know how good it is, how bad it is. I got nothing. But what I do is I'm concerned with managing.
In a Michigan courtroom, judge takes the bench, calm but firm. Before him stands Robert Jr., a man determined to face trial rather than accept a plea. The air is tense, the stakes are real.
Covering a year, which means those trial dates are very, very valuable. So what I do is I tell defendants this. I have a policy. The policy is that today is the last day to enter a pretrial agreement. Now, that doesn't mean you can't, defendant can show up and plead guilty as charged in the trial date, or we just go to trial. Now, that's never to pressure you. It's actually to pressure the two attorneys. Because what I don't like is them dragging you along, dragging me along, dragging witnesses along, dragging alleged victims along, and then on the last day they go, ha, give me the better deal. No, today's the date to give the best deal. So I trust that Mr. Carnes and Ms. Satawa or Ms. Castle have arm wrestled each other a lot, and they've fought and they've blackened eyes and whatever, and they can't get any better of a deal. So it's not to pressure you, it's to pressure them, because you also want to know, is that the best offer I'm going to get? Okay. Plus, you also need to know, no, I want to go to trial, and I need to make sure my attorneys are ready to go. So that's what it's also about. And I also have to bring in about 60 to 90 potential jurors. And they've got to bring in witnesses. I've got to tell other people I can't do trials, any other trial. So that's a lot of moving parts. So before all those moving parts get done and people got to take time off from work and blah, 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 or like Ms. Getz is telling me do other trials elsewhere. That's why I have the schedule, this policy. So again, it's never to pressure you. I don't know anything about the case. All right, so today your attorney's telling me we're going to go to trial. All right, that's great. So now I turn to Ms. Getz and I let her know the answer to her question. Ms. Getz, because I know that not all other judges have this policy that I've just described, I have nothing negative against Ms. Satawa or Ms. Castle. I know Ms. Satawa quite well. So I know that lots of attorneys cut deals and lots of other judges will let them. Therefore, I will wait until probably the week prior till the scheduled trial date here to adjourn. Okay? I'm going to wait till we get toward the end because I'm not going to lose a trial date. But my stand, so there might be 2 cases set for trial on that date. And one of them might be older, although it looks like this is the oldest. So one might be switched.
Attorney Lynn Getz appears for the defense, explaining scheduling conflicts. But the judge isn't here to talk about delays, he's here to talk about accountability.
And then even though I have this policy, in this particular file, well, anyways, that's how I handle it. So I won't adjourn the trial date today. My staff will reach out generally the week before. Ms. Satawa can file a motion, let me know what's going on in the other case, because I don't want somebody cutting a deal at the last minute down there and being ready to do Mr. Shook's trial. By the way, it's not going to be last minute, but it'll be probably the Friday before I'll make a final decision on what's going to happen. Okay. And so again, that's not to pressure anybody. That part of it isn't. That's just to make sure I don't lose one of my valuable trial dates. Any questions about that today, Ms. Getz?
No questions about that. I just have one other matter when you're ready.
Yes, ma'am. What is that?
We are still missing the body cam of my client's vehicle, as well as one other, I believe it's the car cam or the dash cam. We still have not received those. Such, is there a motion cutoff date? We need to do a motion to compel.
Hold on. The court hereby orders the prosecution to make sure that they have transferred physical copies of those videos and information that is just been described by Ms. Getz, and it must be done within the next 7 days.
Can you please state those requested things again?
Yes, it was the dash cam video we still have not received, as well as the body cam when they searched the vehicle.
Now, Ms. Getz, because of that, obviously once the defense receives those, if there is a justification based upon that to have an adjournment in the trial, maybe an expert's got to look at it to make sure it was downloaded correctly, those kinds of things. If the counsel are going to take this case to trial, believe that that would be a justification to move the trial date, now that's fine. You know, to make sure they include that in there as well, right? Because that could be a failure or delay by the prosecution, which Mr. Shook now would cause me to have to reconsider my policy. I don't know what the body cam shows, but anyways, all right. So we've got some moving parts here. I'll make sure that they get that information to you all within the next 7 days. Thank you. Anything else today, Mr. Carnes?
No, Your Honor.
Anything else today, Ms. Getz?
No, Your Honor, thank you.
All right, now Ms. Getz, I'm gonna go off the record here on this file. I'm gonna turn to you to tell you about something else involving another one of your all's clients.
The judge speaks with authority, reminding everyone that trial dates are precious. He manages hundreds of cases, and every lost date means justice delayed for another soul.
Ms. Nancy. Ms. Getz, we also have added to today's docket an arraignment on a bench warrant. This court issued a bench warrant for Mr. Mark Jones. Mr. Jones, we thought may have been in a jail at one time, but he didn't appear at a final pretrial. Apparently it was discovered that he wasn't in jail. We issued a bench warrant. We're going to be addressing him in just a couple minutes, in about 5 minutes. But if I'm going to take probably another case and do a plea, I'm going to say we can bump him to 10:30, which is in about 20 minutes. Could you appear on that one as well, Ms. Getz?
I can.
All right, I'm going to tell you, again, the name is Mark Jones, and it's our file number 25-14107FH. We'll come back to you in about 20 minutes.
Perfect, thank you.
Yes, ma'am, thank you. All right, our next case this morning is People of the State of Michigan versus Sandra Gale Bottoms. This is case number 25-14108FH. Appearances from counsel, please.
Nate Carnes on behalf of the people.
Jeff Harrison, I'm here on behalf of, she's next to me at the table.
Thank you. We are here today on this case for a final pretrial. That was conducted a little while ago this morning between myself and counsel in chambers. Counsel informed me that they intend to enter a pretrial agreement in this case. I understand it's going to be a no contest plea. I've already reviewed an exhibit. I'm just going to hand that to the court recorder and have her please add an exhibit sticker. In the meantime, Mr. Carnes, why don't you go ahead and tell me the terms of that pretrial agreement, sir?
Your Honor, it's my understanding the defendant would plead no contest as charged. The reason for the no contest plea being potential civil liability.
That is my understanding as well, Your Honor.
All right, thank you very much. Thank you, Nancy. Ms. Bottoms, I'm told today that you're going to enter what's called a no contest plea today on the record. It's important that I tell you what the difference is between a no contest plea and a guilty plea. In a guilty plea, the defendant must state on the record what their actions were that caused them to be guilty of the offense.
He makes it clear, today is the last day for any pretrial deals. After this, it's trial or nothing. No last-minute bargains, no courtroom games.
Actual basis. The court is going to look at an exhibit that the parties will stipulate the court can look at. Then I will determine guilt based upon that. Now, a no contest plea can be given by a defendant instead of that guilty plea in a couple situations. One of them is when there is potential civil liability. Civil liability means that the other party, or the alleged victim in this case, could sue you. And there are other steps. If they got a judgment against you, they can go against you, any assets, other things to try to recoup that money. In a criminal case, it works a little bit differently, but that's the difference between a no contest plea and a guilty plea. If you have any questions about that, ma'am, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Do you need me to repeat anything about that guilty plea, no contest plea that I just talked about? All right, thank you, ma'am. Well, today I'm told, I know here in this file, you're charged on what's called a felony information, which is just a piece of paper, and it charges you with a single count. Now on that, it charges you with embezzlement by an agent or trustee. Embezzlement means somebody takes from somebody over whom they have either an employee relationship or a fiduciary or similar conduct involving taking from a nonprofit. But I'm being told that there aren't any other allegations out there involving any other nonprofits. Consecutive sentencing is important to understand because sentences can either be run concurrent, which means at the same time. Let's say a person were convicted of 3 offenses at the same time, they would run concurrent, which means every day served is a day off of each sentence. Consecutive means that they can be stacked on top of each other. So let's say in a case like this, a person were convicted and the judge gave him 2 years, then they were convicted a second time, or they could get another 2 years, so they'd serve those. Consecutive means a total of 4 years. But in this instance, we're just looking at, well, there isn't any other charge, so it doesn't matter. So again, the charge is embezzlement by an agent or trustee. The allegation is that you're an agent or trustee of the Club Cadillac and that you took from them at least $20,000 or more, but less than $50,000. And again, that's that felony punishable by up to 10 years and or $15,000 or 3 times the value of the property that was taken. I'm told today you're going to plead.
For a judge, it's not about pressure on the defendant, it's about discipline for the lawyers. Justice must move forward, not crawl through negotiations.
Plea and I find you guilty, you're going to be waiving certain rights that you would otherwise have at a trial, because you won't have a trial now. Anyways, I'm holding up a piece of paper that'll look that Mr. Harrison gave me in chambers, and it appears to have your signature at the bottom. Is that your signature?
Yes, sir.
Now, did you read through these rights before signing?
Yes, sir.
And did you understand those rights that were listed there?
I do, yes, sir.
Okay. And even more importantly, do you understand that if you plead no contest and then I end up accepting that plea, you will be waiving these rights as they apply to this particular case?
Yes.
So you'll be given up the right to claim that the plea today was a result of any promise, threat, or inducement not told to me today on the record. Have there been any other promises, threats, or inducements to get you to enter this plea that no one's told me about today? Now, Mr. Harrison's probably talked about sentencing with you to give you an idea of what the exposure is. Even though I told you the maximum punishment is up to 10 years and so forth, he's probably talked to you about something called the Michigan Sentencing Guidelines. I wanted to tell you that those guidelines are not mandatory. The court must consider them, and there are some limitations on or requirements that the court must follow based upon how those guidelines are scored, but there is still some discretion within the court, which is me when it comes to sentencing. So I highlight again, the guidelines are not mandatory, but they are a very important tool, and there are certain requirements that limit what I can and can't do for sentencing, but it's within the court's discretion. Do you understand? Now, if I accept this plea, we'll probably continue on bond here and have you come back in about a month or so, but we'll talk about that in just a moment. Before I ask you how you finally plead here, do you have any questions? Now, again, I anticipate the plea to be no contest. I highlight that. I'm not trying to tell you what to say, but sometimes when I turn even in a no contest, people have seen it way too much on TV, they say guilty. So again, in this particular case, on that single charge, Ms. Bottoms, how do you plead?
No contest.
Thank you. Now, before we entered the courtroom, the court was given this exhibit by counsel. It's listed here now as or marked as People's Proposed Exhibit number 1. It is there's a couple different reports. I should call them an original and some supplemental reports.
As the discussion unfolds, the defense mentions missing body cam footage, evidence that could shape the case. The judge immediately orders the prosecution to deliver it within 7 days.
Just a second. All right. This exhibit is a Michigan State Police Department report bearing the incident number of 71-3487-24. It consists of an original incident report that is 4 pages. Then it includes a supplement number 1 that consists of 3 pages. And it also consists of, supplement 2, not that I need it, but it includes supplement number 3. And supplement number 3 has 2 pages, and then behind it there are some other attached exhibits that appear to go along with that supplement. Mr. Carnes, are you asking the court to accept these exhibits totaled together as People's Exhibit 1?
Yes.
Mr. Harrison, any objection?
None whatsoever, Your Honor.
All right, thank you. People's Proposed Exhibit number 1 is hereby admitted as I described a moment ago on the record. Again, as I've already stated, the court did go through this thoroughly before taking the bench today. I'm going to highlight the report described the incident with a date range between possibly March 1st of 2024 through potentially October 16th of 2024. Looks like the report was actually made the day before on October 15th of 2024. I'll note that it covers the venue of Club Cadillac, which the court notes, even according to the report, is a 501c3 connected to Northern Lakes Community Mental Health, and then it's located here in part of the city of Cadillac, out there in Herring Township here in Wexford County. I will also note that it describes here that Ms. Bottoms was not only a member of that program, but then later became a treasurer for the program. I'll note that it appears here that the suspicions rose back in July.
He reminds both sides, evidence isn't optional. Delays and excuses won't stand when justice is on the line. The courtroom runs on proof, not promises.
The supplement number 1, it describes the state of investigation, like the events allegedly did begin in March of 2024. I see the amount that's listed on page 2 of 3 in supplement 1 actually adds, if added together and were all totaled, would be approximately $73,970.59. Even more importantly, I'll also note that on page 3 of that supplement number 1, there are statements that the court does now consider a confession. Oh, by the way, and I've also looked at the portions that were in supplement number 3. Mr. Carnes, do you believe the interest of justice did not require a defendant to state a factual basis based upon potential civil liability?
Yes, Your Honor.
Do you believe that this report contains adequate information and evidence to support the plea?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe the court is in compliance with Ms. Scroll 6.302?
Yes, Your Honor.
Mr. Harrison, do you agree with all those statements?
I do, sir.
Great, thank you. The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds that the information contained inside the exhibit, People's Exhibit number 1, which again was admitted by this court into evidence, satisfies the elements of the charged offense. The court also finds that the interests of justice, as stated earlier on the record, do not require the defendant to recite a factual basis. Therefore, the no contest plea is accepted. The defendant is found guilty of count 1. Ms. Bottoms, this case will now be set for sentencing. That sentencing will occur in about 4, maybe 5 weeks. We do them every Monday morning. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. Now, that report will describe the offense, describe the pretrial agreement, give me information about you, maybe include any prior criminal history if there is any. It will also include a score to the guidelines, which I've already told you were not mandatory, and it will make a recommendation as a sentence. Please keep in mind it is only a recommendation. Quite sure if you ask all of them downstairs in that office or everyone else here in this courtroom, it is merely a recommendation, as I'm very independent and I won't.
Moments later, a new case begins. Sandra Bottoms faces charges of embezzlement. Calm but nervous, she pleads no contest, accepting the court's judgment without admitting guilt.
There are 3 steps that involve you. When you leave this courtroom, you're going to go downstairs to the Michigan Department of Corrections office. They're also known as the Probation and Parole Office. Now, if you take the elevator all the way down, or take the steps, they end at the same spot, you'll do a button hook to the right, go down a little ramp where you see a bunch of soldiers in black and white fighting over World War I. Probably one of the battles of the Marne, but anyways, we won't go into history. You walk down past that sign, go through the door at the end of the hallway, second door on the left is their office. They're going to give you a packet. You're going to open it up, follow the instructions, complete all the information that's asked. on it. Turn it in. They'll also schedule an interview with you, and you have the right to have Mr. Harrison present during the time of that interview. And number 3, Mr. Harrison is going to have to meet with you prior to coming back to court, because he's got to go over that report with you, because you each have to make sure it's complete and accurate before the court gives a sentence on it. Do you understand? If you have any questions about what we have done today? If you have any questions about what you got to do when you leave the courtroom today? And we should be back in about 4 or 5 weeks. Mr. Carnes has got a curious look on his face. Is there anything else over there?
I'm looking at a different file.
He's not even paying attention to me. I hereby hold, no, never mind. No contempt today. Anything further from you today, Mr. Harrison?
Nothing further, Your Honor.
Ms. Bottoms, we'll see you in a couple weeks. Anything from you? Thank you. Your bond continues. We remain, I'm sorry, we are adjourned. Thank you. March, your exhibit, sir. All right, let's see if we
Do you
can, yeah.
want me to see if they want to break out?
Yeah.
Oh, no.
All right. Let's see if we can start working on the Beals file then. Is he in person? All right. Ms. Getz, we're going to put the 2 of you into a breakout room.
Perfect.
So you can grab it well, at least meet
I'll
the
make it.
defendant. There he is. All
Thank
right. Mr. Jones, we're going to put you and an attorney in a breakout room. I'm talking to myself
I
now.
already clicked it.
I got it. All right, next case is people of the state of Michigan versus Robert Beals. File number is 25-14127FH. Appearances from counsel.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Beals. He is present in the courtroom today. It just takes him a minute to get through his seat up here.
All right, thank you very much.
I'm just teasing you.
It's okay. All right, we are here today for a final 3.
The judge carefully explains her rights, the meaning of no contest, the weight of responsibility, and the long road ahead. His tone is firm but not cruel, law with compassion.
Why don't you go, gentlemen, I know what we talked about. I understand that there is some potential issue. This is one of the cases set for trial on November 25th. Right now, we don't have any resolution, correct, Mr. Harrison?
Correct.
You can have a seat, Mr. Beals, if you choose. I'm sorry if I didn't say so.
No, that's fine.
That's all right. But there's an issue with discovery, apparently, Mr. Harrison.
It's not an issue of discovery. I want to be clear about that.
It's an issue with potential experts and
Indeed.
examining.
Yeah, indeed. And we have not yet retained an expert to review the massive data dump from the laptop and/or the footage that was given to us reportedly, I'm not loading up the term, to be that of the body cam worn by the investigating officer. We'd like that opportunity. It's just a couple of things have just come to light between Mr. Beals and our office in that regard. We'd like the opportunity to recognize and investigate that.
All right. So first of all, let's make sure we got this correct. Mr. Carnes, apparently you've given all those.
Yeah.
Right, yep, Mr. Harrison saying, yeah, you've given all the videos to him. That's not the issue. So Mr. Harrison's correct. There's no discovery issue I need to put my foot down on or compel. When were those all given to the defense, Mr. Carnes?
Or 3rd.
Yeah,
This
I'd
year.
say in the normal course of
Okay. All right.
don't know that we'll need a substantial amount of time. It's apparent to me that we will need more than the 2 weeks that are available.
Right.
That's my request.
All right, well, I'll state this on the record, and because I've decided lately that how I'm going to approach requests to adjourn and stipulations to adjourn is going to change. So I need to start saying things like this a little bit more thoroughly here today. There's 2 months that have transpired since the defense has had this exhibit, this record. And I know now, with our new way in the state of Michigan of doing the public defender's office due to the Indigent Defense Commission, there are staff, such as an investigator, that work for the public defenders. I know there's only one over there. But I'm kind of concerned as to why there is no, why in 2 months, nobody can come and say, hey, Judge, I needed an expert. I hired one. So,
Issue really came about as a more recent conversation between Mr. Beals and our office, and a review of particularly the body cam that he completed with my investigator.
okay. All right, so the investigator was involved and sat down with the
Absolutely,
defendant.
yes.
Okay. And just a moment as I consider something else not yet brought up. There's something else I've noticed, but I'm gonna mention it because it's up to the parties. Mr. Carnes, your response?
Your Honor, essentially, I don't take a position on this. I do note we're not running right up against the trial clock and the defendant is out on bond.
Yep, I was gonna note those as well. So the trial clock hasn't necessarily triggered. That was one of the things I was making sure I understood here in the file. I know that he's not in pretrial custody. I can obviously say that, but I wanted to go back to see how old the case was. It's not necessarily got hair on it yet, so it's pretty young. It's no teeth are growing, so it's all good. So it hasn't got any cobwebs on it, nothing like that. So, all right.
From Robert to Sandra to Beals, every name, every file tells the same story: choices, consequences, and the silent weight of justice. In this courtroom, truth always finds its turn to speak.